Okay. All right, have you all had a chance to review the jury charge?
Yes, Your Honor.
Yes.
All right. We're going to go on the record. We're going on the record in cause number 2023 CR 8868, State versus Samuel Bach. Could I have parties announced for the record for the state?
Megan Gowan, Jason Garahan for the state.
Jody Sawyers for the defense, along with Samuel Bach.
All right. Have both parties had a chance to review the updated jury charge?
Yes, Your Honor.
State, do you have any objections to the updated charge?
No, Your Honor.
Defense, any objection?
Yes, there is. We were discussing on the criminal causation. I'm sorry, the causation. I think it's paragraph 4. That the double colons there is not appropriate. So in the paragraph where it says Samuel Allen Bach colon, so that if you believe that.
So you're asking that the colons be removed?
Just that colon. I believe the state's in agreement, putting a period after Bach where that first colon is.
State, are you in agreement to removing the colon?
Yes, Your Honor.
And capitalizing the word so?
And we just took that off and put if, but you can do either one. And it started if you believe. But either way, it doesn't.
Anything else?
Other than, Your Honor, I do not believe there's enough evidence to submit on the element of failure to break. That's the only other thing that I see.
All right, that will be denied. Is there anything else with regards to the charge?
Not from the defense.
All right.
And Your Honor, I apologize. I assume that they did take out, I did not look to verify that the circumstances surrounding the crime and the criminal negligence was taken out.
Yes, that's been removed.
Okay.
All right, can you grab that for me? Oh, no, don't staple yet. All right, if you are you able to make some copies for me? If you make 5 copies of this, thank you. All right, and if you all want to make sure that whatever equipment you need to work is actually working, because sometimes it doesn't work. All right, so on Norma, on Malik Hatch. What we're going to do, can you have his counsel come in? I think she's still in the hallway.
Megan, will you also see if mine will come?
No. I don't know who's.
All right, thank you.
Okay.
All right, so on Mr. Hatch, what we'll do is we'll recall this. Renee, we'll recall it for the 15th.
Okay.
And if he can be here on the 15th, so we can see where we are with that. Are you able to be here? I'll come up for it, sir.
He's back compliant too. Oh. Yeah.
All right, so we're going to recall you on the 15th at 10, okay? It's Friday. Are you able to be here? All right. Thank you so much for dressing appropriately for court. You always do. Just have a seat. Your attorney's going to bring you the reset form, okay? All right, thank you. Yes. Thank you. Scott,
Yes, sir.
Norma?
A two-day trial might sound short, but in legal terms, that's still a lot of witness testimony, cross-examination.
All right, everyone, please be seated. All right, ladies and gentlemen, I know you probably noticed that there are more people in the courtroom than you normally see. It's because this is my morning docket. So the other persons that you see in the courtroom have absolutely nothing to do with this case, so please disregard. All right, what I'm going to do is I'm going to read to you what is called the charge of the court. It's the jury charge. You do not have to memorize it. You'll be given the original when you begin your deliberations. Charge of the court. Members of the jury, the defendant Samuel Allen Bach stands charged by indictment with the committed on or about the 25th day of January 2022 in Bexar County, Texas. To this charge, the defendant has pled not guilty. 1. Our law provides that a person commits the offense of manslaughter if the person recklessly causes the death of an individual. 2. Individual means a human being who is alive. 3.
And there it is, a denial. This is important because objections to jury instructions can become grounds for appeal. Every word in those instructions is battle-tested before it reaches the jury.
3. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4. A person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. Therefore, you cannot find the defendant, Samuel Allen Bach, guilty unless you believe beyond a reasonable doubt that the death of Carlos Dominguez would not have occurred but for the conduct of Samuel Allen Bach. If you believe that another cause, to wit, the conduct of Carlos Dominguez by failing to yield the right-of-way, was a concurrent cause sufficient to cause the death of Carlos Dominguez, and the conduct of the defendant Samuel Allen Bach was clearly insufficient, or if you have a reasonable doubt thereof, you will acquit the defendant Samuel Allen Bach and say by your verdict not guilty. 5. Now, if you find from the evidence beyond a reasonable doubt speed that was not reasonable and prudent under the circumstances then existing, and or by failing to apply the brakes in a timely and reasonable manner, which acts or omissions caused Samuel Allen Bach's vehicle to collide with the vehicle occupied by Carlos Dominguez, then you will find the defendant Samuel Allen Bach guilty of the offense of manslaughter as charged in the indictment, and do not consider paragraphs 6 and 7. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of manslaughter as charged in the indictment, say by your verdict not guilty of manslaughter, and next consider whether the defendant is guilty of the lesser included offense of criminally negligent homicide. 6. Our law provides that a person commits the offense of criminally negligent homicide if he causes the death of an individual by criminal negligence. A person acts with criminal negligence or is criminally negligent with respect to the result of his conduct when he ought to be aware of a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances and viewed from the standpoint of the person so acting. 7. Now, if you find from the evidence beyond a reasonable doubt that on or about the 25th day of January 2022 in Bexar County, Texas, the defendant, Samuel Allen Bach, did with criminal negligence cause the death of an individual, namely Carlos Dominguez, by driving or operating a motor vehicle at a speed that was not reasonable and prudent under the circumstances then existing, and or by failing to apply the brakes in a timely and reasonable manner, which acts or omissions caused Samuel Allen Bach's vehicle to collide with the vehicle occupied by Carlos Dominguez, then you will find the defendant, Samuel Allen Bach, guilty of the lesser included offense of criminally negligent homicide. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Samuel Allen Bach, not guilty of the lesser included offense of criminally negligent homicide. 8. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone.
This is a subtle but crucial reminder. Jurors must filter out anything unrelated to the case. Even seeing extra people in the courtroom could subconsciously influence perceptions, so the judge nips it in the bud.
BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness or investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of the fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty.
Let's break that down. Manslaughter isn't about planning to kill, it's about recklessness. Here, the jury must decide. Was the defendant's driving so careless that it crossed the line into a crime?
Defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. All right, ladies and gentlemen, each side will have 20 minutes to present their closing arguments to you. State, are you ready to proceed?
Your Honor, permission to approach the court.
Yes.
briefly.